Good morning. My name is Matt Platkin, and I serve as Chief Counsel to Governor Murphy. Thank you to Committee Co-Chairs Weinberg and Pinter-Marin, Vice Chairs Corrado and Munoz, and all members of this committee for allowing me to make this statement and for giving me the opportunity to participate in these important reforms. I was unaware that Mr. Alvarez allegedly raped Ms. Brennan until Ms. Brennan told me in March 2018. Ms. Brennan said that Mr. Alvarez had raped her almost a year before after a party for a campaign staffer. Ms. Brennan also told me that the prosecutor's office had looked into her allegations but declined to pursue charges against Mr. Alvarez. As Ms. Brennan told the committee when she testified, I was horrified by what Ms. Brennan said she had gone through, and I told her that I would report her accusation. Just a few weeks prior to my dinner with Ms. Brennan, Office of the Governor employees, myself included, had received training on the state's EEO policy, and so the requirements of the EEO process were relatively fresh in my mind. The training stated that the normal chain of command does not apply when you receive a claim of sexual misconduct in the workplace, and that instead of informing your supervisor, you should report the matter to a designated EEO officer. You are required to maintain confidentiality to the fullest extent possible and not share the allegation any wider than permitted by the EEO policy. Consistent with my understanding of the requirements of this policy, I promptly reported the matter to Heather Taylor on the morning of March 22, 2018. Heather Taylor is the Chief Ethics Officer for the Office of the Governor and also authorized to receive EEO complaints within the office. I informed Ms. Taylor that Ms. Brennan had accused Mr. Alvarez of sexually assaulting her in April 2017. I asked Ms. Taylor to report the allegation to the appropriate contact at the Attorney General's office to pursue an independent investigation. I also informed Ms. Taylor that because I knew both the alleged victim and the alleged assailant, I should not participate in that investigation. I told her this because I wanted to ensure that the process was handled fairly and impartially. The same day that I informed Ms. Taylor, I also informed Pete Camerano, the Chief of Staff to the Governor. As the Chief of Staff, Mr. Camerano was in charge of personnel matters within the administration, and I deemed it appropriate under the EEO policy for Mr. Camerano to be made aware of the allegation. Based on the seriousness of the accusation, we discussed that Mr. Alvarez should be asked to leave his position in state employment. We agreed that Mr. Camerano would relay this message to Mr. Alvarez. At that time, I reminded Mr. Camerano that the state EEO policy has strict confidentiality and anti-retaliation provisions. The policy clearly provides that violation of the confidentiality provisions can result in discipline up to and including termination of employment. Subsequently, Ms. Taylor informed me that the Attorney General's office considered the matter, but determined that the state was without jurisdiction to undertake an investigation. The Attorney General's office concluded that because the alleged conduct occurred before either Ms. Brennan or Mr. Alvarez were state employees, and because neither of them was on state property when the alleged assault happened, the state EEO policy was not implicated. It was also my understanding from that conversation that the state was not even permitted to expend state resources to hire outside counsel to conduct an investigation. If an investigation were to be conducted, it would need to be paid for by a third party, such as the Murphy for Governor campaign. After Ms. Taylor and I discussed the matter, it is my understanding that Ms. Taylor informed Ms. Brennan of the legal conclusion from the Attorney General's office. At that point, I was aware that Mr. Alvarez had been instructed to leave state government, and it was my understanding that he was in the process of complying with that instruction. While I had sincerely hoped that there was more the state could do on the EEO front, Mr. Alvarez was nevertheless leaving. I deemed the matter resolved. I next heard of the matter on June 1st, 2018, when the governor forwarded to me and to Jonathan Burkon, the campaign's counsel, an email that Ms. Brennan had sent directly to the governor. The email did not disclose the nature of what Ms. Brennan wanted to discuss. Because the governor had forwarded the request to campaign's counsel to handle, and because I knew that the Attorney General's office had previously advised that the campaign could be made aware of the allegation, I decided to call Mr. Burkon and explain the nature of Ms. Brennan's allegation. I also explained to Mr. Burkon that Mr. Alvarez had been instructed to leave state service. It is my understanding that Mr. Burkon then relayed this information to Ms. Brennan. I also decided to speak directly with Mr. Alvarez's boss at the school's development authority, Charlie McKenna, to ensure that Mr. Alvarez was indeed leaving. Because of the confidentiality provisions of the EEO policy, I did not disclose to Mr. McKenna the nature of the allegations against Mr. Alvarez, but rather only that Mr. Alvarez should be finding a job outside of state government. I told Mr. McKenna that Mr. Alvarez could call me directly if Mr. Alvarez wanted to discuss the matter. The next day, Mr. Alvarez called me. He was very emotional and was sobbing. He vehemently denied the allegations and explained that he had already been investigated for the alleged misconduct, but cleared. He felt he had rights too, and that he was having his career unfairly ended by an allegation already rejected by a prosecutor's office, and that he had previously retained a lawyer. I nevertheless told him that he should leave state government. He informed me in clear terms that he would do so, but since he was the caretaker for 2 minor children, he needed some more time to find other employment so that he could continue to support his family. I relayed this information to Mr. McKenna. It is my understanding that Mr. Alvarez did indeed find another job and was planning to leave in October 2018 when the Wall Street Journal reached out. Mr. Alvarez officially resigned on October 2nd, 2018, the date of the press inquiry. To be clear, at no time prior to the outreach from the Wall Street Journal did I inform the governor that Ms. Brennan had accused Mr. Alvarez of sexually assaulting her. I was personally present on October 2nd, 2018, when the governor was informed of the allegations based on the press outreach. I can tell you that the governor was visibly shocked and upset and did not appear to have any prior knowledge of the accusation. In the weeks since then, I've often considered and reconsidered whether it was the right decision to not inform the governor about Ms. Brennan's allegations. And I can understand why, especially with the benefit of hindsight, a different conclusion might be appropriate. But I acted in accordance with what I understood, based on the training that I had received to be the legal obligations placed upon me by the EEO policy and its confidentiality restrictions. I admire all survivors for speaking up and sparking this important dialogue. While the administration has already introduced reforms to govern how criminal allegations of sexual assault are handled, it is my hope that the work of this committee can help to even better strengthen our state's laws and policies to ensure that they are as open and accessible to survivors as any in the country. I again want to thank the committee for permitting me to begin my testimony with this opening statement, and I'm happy to answer any questions that the committee may have. Thank you.